Welcome to Telugu NRI Radio Facebook Web Live on US Immigration. We are doing every Wednesday Central Time 6 p.m. on Telugu NRI Radio Facebook Live with famous attorney Lucas Garrison from Burgos and Garrison Law Firm. So this platform bring to give the more information on US immigration to community. Uh, is like we are trying to give the accurate information of US immigration system. Maybe you can connect to the Telugu NRI Radio Facebook page and you can post your questions and get more information. If you have any queries or any complex the question, maybe you can send an email to info@bgimmlaw.com. Lucas will ready to reply instantly. So don't panic and get connected to Telugu NRI Radio Facebook Live and get more USA immigration information. This week we are bringing a lot of information. We will connect with Lucas and get more information this week. Lucas, welcome to Telugu NRI Radio Facebook Live. Welcome to show.
Thank
How
you,
are you?
Venkat. Doing well, doing well. How are you?
I'm good.
Good.
How is the things?
Thanksgiving was great. You know, we had to socially distance and kind of keep it smaller than we wanted, but overall it was a great time spent with family. So how was your Thanksgiving?
Yeah, it's wonderful. So next 2 weeks, the Christmas Eve, I think you were already planned, you were creating. So, well, it was a very interesting element. Eagerly waiting for the Christmas Eve.
Right.
What
It'll
about
be
you?
nice holiday. You know, hopefully be able to take some time off and relax and enjoy time with family. So. Good news all around. You know, we hear the vaccines coming out, so hopefully, things do get somewhat back to normal here in the next few months. So, other than that,
Yeah, that is a good thing actually. Vaccine is out, but the first they are giving to the frontliners, nurses and medical staff. Eventually, they distribute it to all U.S. citizens.
correct.
Yeah.
Uh,
Yes, Lucas. Then we can go for the immigration information. Before going to the further, you can share if anything on recent changes on immigration.
well, I think something that most viewers are going to want to hear that we've been following up and discussing for the past couple of weeks was the HR 1044 House resolution that went through to the Senate, and then the Senate then returned the S386 back to the House, which right now is kind of impacting what's going on in regards to being passed in the session. I know we spoke last week. There's kind of a lame duck session that's happening now, but there is, a key measure pushing forward to get a spending bill passed to keep the government open. Now, this S386 could come back in as an amendment to the spending bill, but really, I think a lot of people haven't been fully educated as far as what has happened to S386 when it was returned back to the House for approval. And there's quite a few points that are really disturbing that would negatively impact, I think, a lot of different people, specifically those who are in H-1B status, who are from India and China. And I just want to go over a few notes that I have here about why this version is not a very good version at all. So, recapping what we just said, I think what this would say is they would want to cap the number of H-1B non-immigrants who can adjust their status to permanent residence annually, which disproportionately impacts both Indian and Chinese nationals. So as much as great news as it would be to have no country cap limits on the EB categories to get rid of the backlog, there would still be an asterisk, so to speak, where if you are an H-1B status and you're looking to utilize this to get your GC, then you're obviously going to be impacted because you're going to go right back into a whole nother backlog. So you're getting rid of one backlog and going to another. That's first. Second, there's only limited protection. So many people who are waiting and have been waiting on this backlog for many years are going to have issues where their kids are getting older. So, if your kid is approaching the age of maturity here, there's only so much time you have before you file. And there's a law that we have called the Child Status Protection Act that will help protect kids from aging out. Now, this current bill wouldn't allow you to apply early enough to protect your children from aging out. So that's also key, especially as we get close to, the high school age, about to go to college. If something happens and you don't get the GC by that time, then now, your kid's going to have to go on and change status probably to F1. And then it's going to delay their ability to get their GC for many years. That's another key issue that's not in this new Senate bill. Third and most important point that I pulled out of the changes that were made is there's additional key restrictions on the H-1B visa program. Now, we all know how tumultuous the past 4 years have been in regards to the H-1B regulations, changes, and things like this, employer-employee relationship, third-party off-site employment, most recently the IFR, where we've discussed the past few weeks in regards to wage level changes, proposed changes also for limiting the duration to 1 year. Fortunately, all that is now, suspended and it's not going to be implemented. But if this passed, then this would allow that to, we would lose ground that we just fought so hard for up to this point. So really, like we've discussed and been optimistic, I really believe this next year we have a very good chance for comprehensive immigration reform. We have two key Senate runoff races that are both in Georgia for January 5th. And if those two seats go to Democrats, then the Democrats would have control of the House, the Senate, and the presidency. And it would make it much easier for us to get this comprehensive immigration reform. And we discussed many times over the past few weeks, I think the most basic reform we could get was, Congress can issue however many visas that they deem necessary at any fiscal year. So at the minimum, we could have it where Congress could say anyone who has had a pending I-140 for 2 years or 3 years, whatever it might be, without a visa available, that anyone that meets that criteria can go ahead and file for adjustment status and that the visa would be available. So there's a lot of many things that could happen. There's a lot of potential for changes. There's probably better options than this 1044 bill and also 386 that most people have been discussing.
This, Lucas, you are saying is 10044 and S386 bill is benefiting for the per country limit removal, but at the same time, it's difficult to get the first time H1B, right?
Well, not so much first one H1B. I think what you want to look at is what restrictions might be included on something. So, most politicians are lawyers, and as lawyers, we all are very technical and I guess you could say tricky as far as like what they want to do. So some politicians, Republicans, might see this as an opportunity to say, okay, I will give you this, but in doing so, I'm going to take away this, right? So that's kind of the crossroads we're at. I really don't see much traction or any hope where with all the other pressing matters that are before the Congress right now to get a bill done to keep the government open, and the CARES Act and everything else that's going on at the moment, I just really don't see, as important as this is probably not the same level of importance as other, bills that are having to be considered in spending packages and so on and so forth.
Okay. So where we are this the bill in House, and how is it? I think a House will open for next 2 days after the Christmas holidays. Do you think this bill will pass in House?
So like what we were discussing a minute ago, I think what we have to realize is that, the Senate Majority Leader, Mitch McConnell, and the Speaker of the House, Nancy Pelosi, are the ones that are working on multiple, bills that need to go through. Okay. So the most important bill right now, there's a spending bill, appropriations bill, to keep government open for the next month. Okay. We don't want the government to shut down. That would be compiling a problem on top of the current pandemic, and it would be crippling to our economy and support services that we rely on and need. That's number one. Number two, we have a CARES Act bill that's, they're trying to do the final negotiations for right now to hopefully get, past any impasses and get that passed so we can get relief to every American workers. Okay. So those are the two main headliners. Mixed in with these, there's probably numerous other bills that are sitting there, and we would just have to see what makes sense to move forward. And whenever you have such drastic changes from one original bill and sent back as a different bill, more or less, something like that, you have all these negotiations, and you'd have to work on that and have discussions and have some sort of agreement or compromise. And I just don't know if there's enough time or enough room for that to happen at the moment.
Okay. So what is the last day session working this year? The 18th?
I believe it's the 18th, but I believe they're going to have to extend that. And, they can extend if they need to. But, I think the 18th of this month is the target that everyone's working for to get something done. So, we'll have to wait and see. I think today is 16th, so that would be this Friday, correct?
Yes,
yeah.
This Friday. Okay. I think we will closely monitor this 386 bill update, and we'll keep posting updates in Facebook wall. You can follow the Telugu NRI Radio and Burgos and Garrison Love Facebook. You can get more information about S386 bill. Hopefully, we will see. It means everyone is anticipating go for positive, but we don't know what will happen in Senate and House. So, because of two different versions, the House and Senate, someone will compromise this. The version, then it will go faster, as per my understanding. So hopefully we'll see and get positive information, positive way from House. Lucas, I'm stepping back to October visa bulletin. Most of the H1 holders apply for adjustment of status in October. Who downgraded the EB2 to EB3? As of now, we don't see any receipt. Do you know any update? Do you have any update on this one? When they will get the receipts and biometrics?
Very good question. So actually, today I followed up again with AILA, which is American Immigration Lawyers Association. We have daily updates. We have liaison committees that reach out to various government entities, one of which USCIS, to see, with the lockbox, how they're processing. So we have a few different events occurring all at one time. So we're experiencing huge delays, with anything to do with the lockbox. Now, if you downgraded your I-140 and you file concurrently, all those petitions go to one lockbox here in Texas. And on top of just being at one lockbox and limited resources there, there's various other cases that are filed, not just people from EB2, EB3 from India. There could be various other people from other parts of the world, different visa categories. And whenever everything's filed concurrently, it goes through this lockbox. Now, on top of everything else, where USCIS might be receiving extra 25,000 applications at one time, we also would note that there's a lot of officers working remotely. Okay. So there's a lot of delay in everything processing. Now, normally we would say that the processing times are 4 to 6 weeks. We've been saying, since I spoke to all my clients, and we really try and give the expectation of 6 to 8 weeks. I think we're getting close to that threshold, and hopefully we start seeing more receipts coming in. But we are aware of the delays, and like I said, AILA is, from feedback from all the immigration attorneys, is really on top of it, and we're staying up to make sure if there is any delay outside the ordinary processing of what we know of now, that we're notified immediately so we can inform our clients.
Okay. So I think whoever applied this in EB2, it means it did not downgraded for apply the adjustment status. I think they got the receipt number and they got the biometric.
Correct.
I think only delay for the downgraded.
Correct. So when you're filing, which would be filing with the supplement J, and you're not downgrading or refiling an I-140 petition, that goes to potentially 2 different service centers and 2 different lock boxes in those service centers. So, the work is segmented and divided up, accordingly. And it just so happens right now, with just the sheer volume of people downgrading from EB2 to EB3, there is huge processing delays. And I know we all want the receipts to come quickly, and it would be nice to have, but we don't want the work to be sped up where mistakes are made or something happens to give a bigger headache. So patience is everything with this, and everyone should be assured that not just the one attorney that handled the case, but there's many attorneys from our group that are monitoring the situation, and we're trying to make sure USCIS is informing us if there is any other issues that come up.
Okay. Lucas, we got a question from YouTube. Amol Deshpande just is asking, is it difficult to get the functional manager under EB1C approved for the functional manager job abroad in the United States?
Yeah, so EB1C would be, a category for a manager and an executive, from abroad. You have to work abroad 1 out of the previous 3 years. And when you come here, if you're here on an L1 A visa, you can apply. You don't have to be here on an L1 to apply for the EB1C, but the process is pretty similar. We have to show similar ownership between the 2 entities. We have to show the need, the people that underneath the manager's position that would support the position. So there's a lot of different factors involved. It's very much evidence-driven type of case, but it's a similar process what we did with the EB2, EB3s, as far as like filing I-140s and things like that. Was there any other additional question about the process, or? Okay.
Amol, I think you got the information. If still you want more information, you can send email to Lucas info@bgimmlaw.com. Maybe if any complex question, maybe you can send an email and get more information from Lucas. Thank you, Amol, for your question. I'm requesting if you have any questions, maybe if any topic, you can post in YouTube or Facebook Live page. We can address your questions. So, Lucas, last week we discussed about Trump administration will bring new rules on H-1B. Can you share if you have any additional information on that one?
Well, we kind of touched base a little bit earlier in the show, and we spoke last week and the week before pretty well in depth about this. So the Trump administration produced an interim final rule, and this is what we've been referring to as the IFR. So under IFR, there were two agencies that were implementing a rule. We had Department of Labor, and we also had Department of Homeland Security, which incorporates USCIS. Under the DOL rule with IFR, there was the wage level increase. Okay, and from there, U.S. court has blocked the wage level increase, and basically now there was another yesterday a memorandum by court, an order stating that DOL has to go back now and readjust the wage levels to what they would have been for any LCAs or prevailing wages that were filed and certified during that time with the higher wage levels. That was one. The other one was the DHS provision with USCIS, which would limit H-1B approvals potentially for 1 year at a time. It would incorporate the employer-employee relationship, and it would also reincorporate the third-party offsite employment, availability of specialty occupation, or like what we've seen with these RFEs for the past year and a half. And hence that means you'd have to get all the client letters, you have to get all the contracts, work product, et cetera, et cetera. So good news is at the moment, the implementation of these rules has been suspended. Now, the administration can still go through the rulemaking process for these rules and do everything legally. But the problem is I don't think there's enough time for the notice and comment period to happen and for the government to review all the comments before a new administration's in office. So if this is still ongoing by the time the new administration's in office, the new administration can just pull the plug on this before it becomes a final rule. And that's what everything's trending towards at the moment.
Okay. Yeah, thank you, Lucas. Hi, everyone. If you have any questions, you can post in Facebook and Facebook or YouTube. We will address your question, or else I can ask the very general question on immigration, H-1B, green card, and 485. Lucas, I have most of the events. I have categorized. I have a lot of questions on immigration. Mm-hmm. The first is the Biden nominated Alexandro Mayorkas as Secretary of the United States of Department of Homeland Security. So, he is confirmed or about to confirm as a Secretary of U.S. DHS?
So the way it works is the president, and of course there can't be any formal nomination until the president is sworn in. So as soon as the president is sworn in, he's officially president of the United States, he can nominate his cabinet. Now, when he nominates the cabinet still has to be, confirmed to be an officially recognized in that position, they have to be confirmed by the Senate. So, all in years past, this would be done within a month or two. But here recently, things have become more partisan in Washington, D.C., where people challenge every little detail. Some of these nominations drag on for quite some time. And it doesn't mean that the person nominated cannot act in a certain capacity. And that's why we see acting secretary or acting attorney general, but they still don't have the full authorization to make certain policy rules or changes, at that time. So to give you an example, I think his name's Chad Wolf, is acting Secretary of USCIS or DHS, one of the two. Court ordered them, USCIS, to go ahead and accept DACA, cases again, and they issued their own rules where if they do accept, then they're accepting under these conditions. And a lawsuit was, made challenging the way that they've gone about re-implementing this. And the judge pretty much said, look, as an acting director, you're not able to fully incorporate policy or rules or any type of changes. So even though the person that you've discussed would be nominated and be an acting director, they can't, function in the full capacity until the Senate confirms them. So, I don't foresee, this only comes up if you're someone like Donald Trump who wants to issue their agenda. And by when I say agenda, what I mean is make drastic changes to a system that impacts a lot of people in a negative way. Then there's going to be a lot of issues where there's going to be a lot of challenges. If a new administration comes in and they're trying to help people rather than hurt people, or they're trying to help fix a system rather than break a system, there's probably less bumps along the road, and it being acting versus fully confirmed director is probably not as big of a deal as what it would be under the current administration.
Okay. So I think Alexandro Mayorkas worked in Obama administration, director of USCIS.
Correct.
So I think he's majorly involved in H4 implementation, H4 EAD implementation, and other roles. If he confirmed as a secretary of DHS, what do you think employment immigration will be liberal, or going to be implemented new rules on H4, maybe any employment immigration system?
Well, I think what you want to do is you want to have someone, either liberal or conservative, you want to have someone who knows how the agency works. So we want to know what practical changes can be made and how that's going to impact. And I'll give you an example of that. So 2 years ago, when we filed for H4, this administration had the bright idea to say, let's do biometrics. Let's make sure that there's not a lot of these, criminal masterminds breaking the law that are in H4 status, and so what ended up happening is you had a process where people could expect to have an approval within a couple of months, or if they filed premium processing with the principal H1 immigrant, then or visa holder, then you could get a result within a couple of weeks most of the time. And by implementing this new biometrics requirement, it separates the petitions and the application from the petition. And what it does is now we're seeing H4s taking 5, 6, 7 months to fully be processed. And that's not, sound policy, no matter, what side of the fence you're on. You want things to run smooth. You want it to be efficient. And you don't want to make changes just because you want to make a change, if that makes any sense. So the more you're involved with the agency, the more you know what's the problems, how to fix them, how to keep things running smooth.
Yeah, hopefully this H4 biometrics came in Trump administration. hopefully in Biden administration will remove this biometric for the H4. It means literally it is a long waiting process for H4 and H4 EADs. The most of the H4 EAD holders are affecting for their employment. I'm seeing a lot of cases, even they did not get any, they get the receipt, but they did not get the biometric date, and it's not processing till March and May, June. Even who applied in March and April, they still are pending.
Correct.
It's a little bit, it means the system is getting the complication on the H4 process. Is H4 is nothing, but if you think H4 is nothing, but it getting complicated to get approval on approval H4 and H4 EAD.
Correct. Well, here's something else. I mean, if you're dragging this out to where it's almost 1 year for an approval, and forget the EAD part, let's just talk about H4. Well, what if there's an emergency after 4 or 5 months and you need to travel home? Well, now you'll still be in status if you have a pending application, but once you leave, your application is deemed abandoned and it's going to be denied. Then you have to go. It's almost like it's a waste of money at that point, because you're not really getting what you paid for. And at the end of the day, it's a lot of money to get these H4s and H4 EADs, and it puts a lot of burden and pressure on people if they have to make decisions about travel or something else.
Yeah, you brought a good point, actually. So, yeah, if any application is pending, they should not travel outside of United States, right?
Correct. So, as soon as you depart the United States and you have your H4 extension pending, the application is going to automatically be denied because it's deemed abandoned where you've left. And of course, logically thinking, as soon as you leave, if you're going to get a new I-94 with a new duration when you come back in, so the extension at that point is not needed. But the issue is, there's a lot of things that might go along with that. So what if you also have a EAD pending, and maybe you get the EAD, but the dates aren't the same, or maybe there's a lot of issues that cause mismatches, which cause other issues in the future where maybe someone who's the principal H-1B visa holder sees I have an approval till 2023, but the H-4 somehow doesn't match that in the future. So that, there's a lot of things that do come up in these scenarios.
Okay. Let's say one scenario, as per your discussion, just I got one question on my mind. So we'll take one scenario. So H4 is a pending. The H4 applicant travel outside of United States as emergency. After a couple of weeks, the H4 approval, and at the same time, they got approved the EAD, H4 EAD. So once they travel back to the United States, so they will get the new I-94. So will they work on H4 EAD, or they need to apply fresh H4 EAD?
Well, so technically, I can imagine it would happen maybe in a certain circumstance, but as soon as you depart, they're both going to be, denied. So there's, and that again, like with all the fees and everything and time wasted, it's a huge amount of money, especially, by the filing fees take up quite a bit. We're talking about almost $1,000. And then at the end of the day, if there's an emergency, because you have to wait for so long, you're forfeiting $1,000 and all the lost time that you might not be able to work.
Okay. It means when they travel to United States, when they left to the United States, automatically deny the application, you mean to say, all right?
Right.
Okay. Lucas, just we're discussing about the new secretary of DHS. Here, just I want to understand, The DHS and USCIS is same agency, one single agency, or two different agencies?
So Department of Homeland Security encompasses, sub-agencies, so to speak. So you have USCIS, Customs and Border Patrol, et cetera, et cetera. All these agencies, have their own purpose. ICE is involved under this umbrella. Okay. So the main, secretary for DHS would, want to make sure and coordinate with all the other sub-agencies within there, right?
Okay. So, yeah, I have some questions on H1. We got one question in the Facebook, YouTube, the Venkat Chituri. Will there be any complications when H4 aged out apply for F1 adjustment of status while is I-485 adjustment status is still pending?
Is there any issue if H4 is changing status?
Yeah, it means I think the primary H1 applicant apply the adjustment of status and also dependents. So if dependent child, the aging maybe 18 years or 17 years or 18 years, limitation is 18 years, right?
Correct.
Okay. So if dependent child apply the 485 adjustment status, the still is pending. So we know that is currently we applied in filing date, not final action date. It means that the date will not be locked. So the aging out, the child, they apply the F1. He's asking, is there any complication this process?
There's a potential complication where, so when you file for adjustment of status, that's what we would say is immigrant intent. F1 visa technically is a non-immigrant visa, where once you finish whatever you're going to do studying, you say, I'm going to go and return home. So there could be some complications with that, but you have to remember, if you file for a kid, but the final action date is still years away, you're really, there's not much benefit to that depending on how old the kid is. Now, when we first started the show today, we were discussing the Child Protection Status Act and things like this. Now, under the Child Protection Status Act, there's protections there for kids who might age out, and it allows you to, go beyond the limit because there was delays in processing of the application, or a certain time exists or certain circumstances were there to cause the delay. In doing so, you can recapture the time, just like how we say we recapture maybe time for H-1Bs because of travel or other things. So in that circumstance, that would be possible. But if you're, EB2 and you downgrade to EB3 because your priority date is 2013, the final action dates are still 2009 for EB2 and 2010 for EB3. And that's going to cause, still multiple years before, under the current system, before something like that happens. So the best case scenario would be if you have a story like that, and I would imagine whoever submitted the question, if that's your scenario, the best thing to do is, here in a few months, if there's any traction with a comprehensive immigration reform, reach out to your representative, reach out to the senator, let them know the story, let them know the importance, because if the kid misses that opportunity and then has to change status to F1, that's going to, cause huge delays. And, you can sponsor your kid still as a legal permanent resident once you have that designation. But, there are limitations whether or not your kid can be married, you see. So if your kid gets married after you petition for them, and you're still a legal permanent resident, that puts them in a whole nother category. And that might delay them another 2 or 3 years. So it does have complications to it. That's why, I really feel like this next few months, this next administration's really going to have some plan where people can really plan their lives and not, just rely on the current status quo where their visa might be available in 50 years.
Yeah, this is some burning points. Whoever the child is turning out to the 17 years is holding out the 17 years or 18 years. I mean, so they will leave the separate branch. Actually, they will go to the separate process. The little bit impact the kid. So hopefully, the Biden administration will bring the comprehensive immigration system. And you keep saying this, Biden will do some comprehensive immigration system. So hopefully, we will get implemented. It will implemented within 100 days or maybe within a couple of months. Hopefully, it will get benefited to all whoever apply the 45 adjustment status. The kids will be safe and get pursued whatever they dreams or maybe the desired things, or else it will get some disturbance. It will get some disturbance as per the studies and their career path.
And that's part of, as a personal note, that's part of why I was interested in this field. Is I grew up, here in Dallas. And I grew up with kids who were, immigrants from different, countries. And as you're growing up among your friends, among your peers, the last thing you would ever want or think about is that you might have a certain opportunity, that you have a trajectory in your life. I want to go to this school, or I'm going to do this, and you make plans, and then someone else is not able to make those plans. And that's what has always touched me and made in a lot of things that I think about. And hopefully other people can also be aware of these hardships. And we want to make sure we don't have hardships, because the worst thing that can happen is someone who can contribute to society or make an impact in this world is limited in some way. And we don't want that.
Yes, true. So Lucas, as you said, is it means we requesting you all. You can reach out to your local representative, congressmen, and the senators. Explain your scenarios and maybe push to the Biden administration get comprehensive immigration system so that the kids will get benefit for their future. So contact your local representative and congressman, explain your scenario. Maybe they will understand, and they will push to the maybe House or Senate is right direction, maybe positive way for the green card system. Yeah, Lucas, I have some questions on H1B. Yeah, one question is, Lucas, let's say H1 holder is getting to the extension is expiring, but he want to extension. It means this is I'm not sure, but this question is right or wrong. But just I have in my mind, I want to clarify this question. Some reason he doesn't have the W2 is not matched to the LCA.
Uh-huh.
So what is the consequences to apply for extension?
Well, not so much an extension. Anytime you file a new I-129 petition, this is very critical. And this is also, part of what the benefit of having an attorney handling the case. We always want to make sure that the previously approved I-129, H-1B petition, that LCA that was used matches what payroll documents you currently have. Okay, because sometimes there's an administrative error, or things occur where the records aren't updated. But if you submit an H-1B case where the LCA doesn't match the payroll, it's going to cause a question immediately, addressed in RFE for the current amendment or extension, saying, why are you working from location A when the LCA is at location B? And there's more than normal commuting distance involved, let's say more than 50 miles apart. Usually this comes up where someone's in a completely different state. So when something like this happens, really, unless there's a valid reason that we can introduce saying, there was a huge mistake that was made, or the package was sent to USCIS, but we never received a receipt notice, or if there was something like that, we could overcome that. Usually, I would say what would normally happen is USCIS can still approve the case, but they'll revoke the I-94, which means the H-1B employee will no longer be able to work, and they would need to depart the country, or and that limits you also. So even if you have an employer, and let's say the employer made the mistake, and you say, hey, I'm going to leave, I'm going to go work for someone else. Well, at that point, without the I-94 being active, you can't transfer to a different employer. So you really are stuck. And that's why we want to always treat these I-94s like if they're made out of gold. We want to always protect them, make sure everything is done correctly with the LCAs, with the petition filings, so we don't have that issue.
Okay. So you mean to say always it should match the LCA and W2 while extending H-1B and transfer the H-1B.
Correct.
Both purpose, right?
Correct.
Okay. Lucas, I have questions on green card I-140. So it means we know the AC-21. Once I approve the I-140 after 180 days, the employer will not able to revoke. Is true or?
Correct. So once you have an I-140, for 6 months, the petitioner can't just revoke the I-140. So you're able to port that and keep your priority date with another employer. Now, here's something that has changed here recently, maybe within the past 6 weeks. There's the adjudicator field manual, what the officers go by in determining what does it mean for a same or similar job to be, from one employer to the other, that type of analysis, that's been enhanced to where now a petitioner needs to show a little bit more detail to show that the jobs are similar or the same. So just saying like, for example, a software developer versus software developer is the same thing. Maybe now we need to show, and it's always best practice to do this, to show like, well, I have Java experience here, and we need to make sure this other job matches with the same environment, so to speak. So we can show that they bridge and they're connected and are same or similar in that regards.
But in similar, the H-1B holder pursue the new role is a senior programmer or maybe lead of the programmer or project manager. Can we?
Well, you have to remember. So what you're doing under H-1B is not necessarily what you're looking at for an I-140. So I-140 is for proffered future employment. Like you have your job offer. Once you get your green card, this is the job you're going to perform. Okay, so in the meantime, if you have like a senior Oracle database manager, something like this, that's different. That could be a different job than what your analyst position might be on your I-140. So, and that's a lot of this comes into play with having a good attorney or someone who's knowledgeable enough to help navigate these areas, because there's sometimes, certain circumstances make it where it's just not possible to maybe port something. In other circumstances, you might want to avoid pitfalls so that you're able to, have these opportunities taken care of. So, it's really a case-by-case basis. And, we use this analogy all the time when we say that, everyone's case is much like their fingerprints, right? No one shares the same fingerprint with someone else. So we have to always analyze these cases individually as unique jobs, as unique positions, because if we just do, a rubber stamp or blind processing, not really paying attention to what makes this unique, that's where you can get into trouble.
Okay. Lucas, I have a couple of more questions on this I-140 revoke questions. Let's say one H-1 holder worked company A and got I-140 approved from company A. The later, maybe after 1 year, he moved to the company B. Mm-hmm. So technically, the employee is not working company A. So company A, is there any chance to revoke the I-140? Because employee is not existing in his company.
So here's the circumstance, right? AC 21 was written and modified and has been modified to protect the worker. When we have H-1B visa holders, we have issues that come up where people are tied and they might feel pressure that they have to stay in a certain role or a certain circumstance, and they don't have the freedom to move jobs. This becomes more evident when you get to your 4th, 5th, or 6th year, right? So even if you have the I-140 and you're beyond 6 years, okay, you might be hesitant to change employers because you're worried if I change and I lose this, I can no longer extend my H-1B visa. So AC-21 was created to say, look, and the last changes were made, I think, 3 years ago, as far as how this goes. They want portability to be easier for the H-1B visa holders, not more difficult. So even if the petitioner somehow, revokes the I-140, that other I-140, the I-140 that's used can still be used to go beyond the 6 years. And you can use that. You don't have to have a new I-140 with a new employer. The only time that's going to come up is when it comes time to file your green card. And then, of course, you're going to need to have an up-to-date I-140 or someone who's going to sponsor you. But really, a lot of these provisions are created to protect H-1B visa holders. We don't want, for every good employer out there that supports their employees and really takes care of them and wants to make sure everything's goes well with them, there might be two employers who have nefarious attitudes towards H-1B visa holders and take advantage of them. So okay. These laws are made to help protect the worker.
Okay. But here, just I rephrasing this one, because this is somehow some gray area, they're not understanding the process. Let's say if even company A employer withdraw the I-140, the approved I-140 still exists in future. Beyond the 6 years, they can use this old I-140, the previous I-140 for the extension. That is correct, right?
Correct. Now, the employer, after 6 months, the employer shouldn't be able to withdraw or revoke the I-140.
Yeah, here I understand. There is an option or not? So that is a question.
No. So once you have, you're fine. People are really knowledgeable about getting their copy too. So sometimes, you might not have I-140 in your hand. There's other ways of getting the copy. And that's, I'm sure, pretty much common knowledge amongst the H-1B visa holders.
Okay. So I have some questions on I-485 adjustment of status. So the same thing, it means, let's say H-1B holder applied the 485 adjustment of status. He got the EAD and advanced payroll. So just I want to know, after 180 days, can he move to the another company?
So that's a very good point. The short answer for adjustment purposes would be yes. This would be similar to when we filed the I-140 and we're saying we have to have a same or similar position. Now, let's say in my scenario, I have a priority date of 2013. I'm currently in EB3. I downgraded. EB3 final action date is still 2010. So I'm still multiple years away. So let's say I wait 8 months, I get a better opportunity. I want to change from my current employer to a new employer. Well, I can do that and have the freedom and knowledge and security to know that once I change once my GC final action date becomes current, my new employer can go ahead and sign a supplement J, a 45 supplement J, with a job description that's same or similar to what was filed for my initial I-140, and that would be fine. And either an RFE will be issued prior to the interview, or you can bring that with you to the interview and give to the officer. And there's pretty much not much more of a requirement other than that. So again, what we want to do is make sure people have the freedom of take care of both of their career and make the best decisions for their families. And that's what the AC-21 provides for that portability.
Okay. So on same, I have the additional question. So 485 adjustment. Let's say the recent changes in October with Bulletin, most of the H1 holders downgraded to EB2, EB3. So if any H1 holder is downgraded to EB2, EB3 for applying the new I-140, this application, is there any chance employer will revoke this downgraded I-140 application?
Well, I mean, there's always a chance for anything, to be honest. So, I mean, yes, they could withdraw the petition because, you still have to wait for this to be approved before the 6 months starts. So, yeah, if an employer has downgraded, just because you have EAD in your hand or something else, if the I-140 has not been approved and it's not been more than, 6 months after the approval, then there might be issues depending on your relationship with your employer.
Yeah, it meant the same terms and conditions will apply for the new I-140. Once approved I-140, it should be 180 days meet to not revoke the new I-140, right?
Well, correct. So you're filing concurrently. Now, the rule states that if your adjustment of status is pending for more than 6 months, you can port. But let's say it's going to, most people filed I-140s in regular processing. So let's say it takes 7 or 8 months for I-140 to be processed. Now, if your adjustment's still pending for more than 6 months, but your I-140 is yet to be approved, your employer can always revoke or withdraw it, correct?
Okay. Yeah. So I have another question on 485. Let's say we apply the 485 adjustment of status is still pending. Due to some emergency, I have to have travel to outside of United States.
Mm-hmm.
The same consequence you explain for H4, or is there any difference for 485 process?
So it's a very good question. That's what advanced parole is going to help protect. Okay, so you do have a certain window of processing times here where you really need to stay in the United States while this is processing, because if you travel before you get the advanced parole or EAD document, that can be fatal to your pending adjustment of status. Now, there's certain circumstances that come up and emergencies that arise. But yes, you really need to have those documents in your hand before you depart the United States if you need to.
Okay. It means to this safer side, we have to stay until get the EAD and advanced payroll approved.
Correct. Now, this is also going back to H-1Bs. If we're assuming all these scenarios involve H-1B, an H-1B visa is what we call a dual intent visa. So if you did have to travel and you had to get stamped, you're filed already your adjustment of status, which means that you're showing immigrant intent you want to stay in the United States, right? That's okay. But, there's certain circumstances where maybe people from other countries, they're here as a student, and they go ahead and file, adjustment of status as while they're in F1 status. And even if they have advanced parole and employment authorization, it might not be advisable to travel, because if there's somehow, advanced parole is not a guarantee. It's still discretionary whether or not to let you back in. So if there's any requirement where you would have to get a stamp, you're pretty much violating your non-immigrant status as an F1 visa holder, because now you're saying, hey, I want to stay here. And that would be in conflict with what you agreed to when you received your stamp. So there's always, like I said, there's always specific scenarios. I know it's very difficult right now. We're in the middle of a pandemic. A lot of families have been affected by this pandemic, and the need for travel is, has been really significant, as families go through certain hardships. So really, we don't like people traveling if they don't have to, but if you do have an emergency, it's best to consult your attorney, discuss all options and possible consequences that could arise if you do depart the United States.
Okay. Yeah. Thank you, Lucas, for information. Yeah, we discussed a lot of questions today. We touched almost each segment. Lucas, we got another question from YouTube from Vishnuvardhan. He's asking about the 2022 H-1B lottery. Any updates or prediction about H-1B lottery 2022 is going to be random or wage level lottery? It means recently we discussed a lot of things. It's gonna change everything, right? So is a random? Will it be random lottery or wage level lottery?
So the comment period is closed on that potential rule change, and right now, all the comments are being reviewed, and hopefully we bought enough time by having enough comments put in place that it flooded the system, so to speak, and delayed a little bit of the process. If this does become a rule, it is going to impact, not only fiscal year 2022, but every year thereafter, unless we change the rule again, where instead of a blind lottery, that turns more into an auction where the highest bidder wins. And I really don't know how practical that can be, because currently, as the system is set up, there's not a way for us to incorporate LCAs. We cannot incorporate wage to be paid. It's just basically your passport, date of birth, your name, and the petitioning company. Now, even if you could incorporate an LCA, let's ask this question: how would that even be fair? If you're a wage level 2 in the Bay Area under 151132 SOC code, you're at $120,000 a year. If you're here in Dallas under the same SOC code and wage level, you're at $94,000. If you're in Florida under certain places, the wage level could decrease down to $75,000. So if you're looking at a position as a merit-based or whatever they want to call it, the opportunity, just because the same job can exist in multiple places with multiple different salaries. So I don't know how they're going to incorporate a system to make it fair, because not everyone works in California, not everyone works in Texas, not everyone works, this program's, for everywhere in the United States. And that's what the wage levels and the Department of Labor with the Bureau of Labor Statistics, that's what all that data is for, is to make sure we have an appropriate wage that's the prevailing wage for that position in that location.
Okay. So is there any, if this no incorporated in new fiscal year 2022, do you think they will select based on the location and code, the wages? Let's say is the Dallas is applied for the thousand H1B in the same category, same code, will divide. It means they will choose the based on the location and code and choose the maximum. It means a maximum LCA.
Well, that's kind of what the rule is hinting at. But again, I don't know how they can incorporate that into the current process. The current system we use, the registration system, doesn't have any, correlation with Department of Labor or any of these other, the flag system or any of these other systems we use to file LCAs, much less determine. There has to be some kind of a sliding scale or something there if they do implement something like this, because we have to compare apples to apples. It wouldn't be fair if you're a wage level 3 at a certain salary and then a wage level 1 in a whole different area could be potentially higher than your wage level 3 salary. It doesn't make sense. Plus, I think what a lot of people also don't realize is these wage levels don't really have anything to do with specifically the individual itself. The wage level is designed by Department of Labor to determine the appropriate wages to pay for the job that's offered for anyone. If it's a U.S., whoever might work at this job, not so much that I have 15 years of experience in doing this, this, and this. So the way it works is we, pull basic data to see what's the basic entry-level requirement for education. Usually for H-1Bs, most all these positions, we find it's a bachelor's degree. Okay. If we require anything above a bachelor's degree, so if the position requires a master's or a PhD or something like this, we add 1 point for each education increment that goes above. If the physician requires beyond so many years of experience, again, that would be incremental increase in wage. If the position supervises other people, that would increase the wage level. So that's the way you look at wage levels, and that's the appropriate way of determining what the appropriate wage level is. So I can confidently tell you that if you choose wage level 2, I know that if you're I can look at it and say, well, we could require it's a master's degree with 2 years of experience or 1 year of experience. That would get us to wage level 2. If I have a minimum of a bachelor's degree with 3 years of experience, that would get us to wage level 2 for, something like 151132. So there's a lot of factors involved, and it's not always just looking at a wage and saying, I make $100K a year, therefore my wage level should be wage level 4. Right. So there's a whole science to this, or legal analysis to this that it's pretty complex. It's not as straightforward as most people might imagine.
Okay. I think still we don't have much information about this higher wages lottery system. We have the short-term period, even less than 3 months, maybe 3 months. So I don't think USC is going to implement the process. If they want to start new process, they need to enhance the system. I don't think within this 3 months will do, because right. The new administration is taking the January 20. In this situation, I don't think they won't touch the new bill. Maybe eventually they will think about this one, but fiscal 2022,
once it becomes a rule, it is kind of an obligation where they have to follow the rule. They can't just ignore the rule. But at the same time, like what you also mentioned, who's making the changes to the software? How is this implementing changes to a database? How are we doing that? I mean, it's a whole complex new structure that they're going to try and implement. I don't know how that would work with what we currently have.
Yeah. Yes, Lucas, we will we will monitor this new rule, and if any updates, we will post in Facebook page. So I think we 12 minutes past 7 p.m. So I think we discussed lots of information today's show. So apart from this, do you have any additional information you want to share to our viewers?
Well, this past month or 2 or 3 months has been really tumultuous as far as changes, proposed changes, lawsuits. So there's still a lot of action that we have in the final 3 weeks of the year, or 2 weeks, and some change. But all I can say is, it's been a real positive year overall for H-1B visa holders, for the GC process, for people who have been, waiting for quite a few years to file the adjustment of status. And, hopefully we can continue this trend in positive results into next year, and hopefully see some really major changes that impact everyone. And all I can request is that you follow us on our Facebook page, both at Telugu NRI Radio, and then also at our law office page. It's Burgos and Garritson Law. And we try and update the community as things change and as news comes out. So, and then of course we also have this forum every Wednesday at 6 o'clock with Venkat and myself. So we encourage everyone in the community, please participate, because you might have a situation or scenario that impacts you, but there's probably 2 or 3 other people with something similar, and it's actually helping them out with your participation, because you're raising an issue that they might not hear while it's live, and they might see it on YouTube or a replay on Facebook, and so we're really it's a community benefit here. We try and help everyone out and do be a service to the community.
Yes, thank you, Lucas. So thank you everyone who ever participated today and posted question. Amol, Venkat Chituri, and Vishnuvardhan. So we are requesting to you participate every Wednesday Central Time 6 p.m. You can post your question on Facebook page, or you can send email to info@bgimmla.com, or you can send an email to info.telugunradio@gmail.com. So we will try to provide accurate information as per your scenario, and we will try to give the more information so that you should not panic on immigration system. We are trying to simplify USA immigration. You don't want to panic on your scenario. Just come. You can post, or you can send email to Lucas. So the Lucas is ready to help to you and the community. We are requesting your participation is very important, so that you can get the more information and you can react on scenario. If you have the more information, you can take a better step should not fall into the complex immigration system. We are trying to, these sessions on every Wednesday. Today's session is in Facebook page and YouTube Telugu NRI Radio. You can visit later and see the entire the 1 hour 60, maybe 1 hour 15 minutes video. You can check all questions, all information of today the show. So we very thankful to Lucas to participating every Wednesday and providing information to Telugu community. We thankful to you, Lucas. Thank you very much. We will continue to the same show for every Wednesday, the Central Time 6 p.m. So I think I'm completed today. We completed the show today. The signing off from my side, maybe from Lucas.
Yep.
We will catch next week, maybe next 2 weeks, maybe Christmas Eve. We need to think everyone is holiday mood. We'll see how does it work, or else we will catch up in New Year first week, 2022. Welcome to 2022. Thank you, Lucas. Thank you very much.
Thank you, Venkat. We'll talk to you soon. Everyone have a safe and happy holiday.
Yeah, thank you. Happy holidays.
Bye.
Thank you very much.